everybody, and welcome back to the Law Unscripted. Now let's talk about relevancy. Relevancy is arguably the biggest topic of all of the federal rules of evidence. A piece of evidence, testimony, or otherwise cannot get in unless it is relevant to the cause or question of the case. It has to directly relate in some way to the facts, circumstances, legal elements of the crime, legal conclusions. It has to relate. Everything that is introduced ultimately has to come down to the question, is it relevant? It may get around a hearsay rule. It may be an exception, but I still can't get it in if it's not relevant. If you find yourself asking, well, who cares? Then that's a question of relevancy. Is it really going to make a difference? Is there a way that that fact, that piece of evidence, that testimony, that witness, sometimes a whole witness, will make the likelihood of a fact or a conclusion of law more or less probable, more or less likely, that it will give something? Will it be neutral? Then, Is it completely random and off the wall? You usually won't get those types of things. Most of the objections I argue with regard to relevance on either side are very minute. It's a very specific, okay, well, that's fine that the expert is testifying in accordance with DNA, but it's really not relevant for their butterfly collection. Okay, they want to talk about their butterfly collection. That's nice. I'm sure they're an expert in butterflies, or it's some kind of research that they're doing that affects their DNA work. I don't know. But ultimately, whether that person, this expert, collects butterflies too, is completely irrelevant to whether the DNA that they assessed is the defendant's DNA or not. That's an easy example. They are not always going to be this easy. These are very intricate fights during objections. And honestly, I have made more relevancy objections in my entire 18-year career than any others. Most people assume, especially for your mock trials, which are designed to create evidentiary issues, most people think, oh, it's going to be hearsay. Hearsay is going to be everything. Well, no, because the reality is that by the time you get to trial, both parties are mostly going to try to avoid hearsay issues. They're going to have looked through their evidence, talked to their witnesses, coached their witnesses as, you can't say what Aunt Mamie said. You can't. I'm going to ask you a question, but you cannot say that. It's not admissible. They're going to try to preempt a lot of objections to authentication, to hearsay, to character evidence by giving notice if it's character evidence. So a lot of the more complicated rules that we're looking at in evidence are going to be taken care of. You're not going to have to worry about them, but you are going to still have to question, is it relevant? Is it relevant to this case? All trial testimony, all documents, all evidence have to meet the threshold question, is it relevant? Not just is it relevant to life, is it relevant to you, but is it relevant to this case? So then after you determine relevancy, then you get into other things. So even if it is relevant, it may not still be admissible. So even if it's authentic, it may not be relevant. Even if it's relevant, it may not be admissible. It may be hearsay. It may be something else. To introduce something into evidence at trial, you have to have evidence that is relevant, material, and admissible. That's what you have to have. You can't have one or the other.